This is an AZ Court Help Legal Talk on how to represent yourself in a divorce or child custody trial by Julie LaBenz of LaBenz Law, PLLC. Thank you.
I'm assuming you all have a trial set, or maybe you are anticipating that your case is going to proceed to trial. And you're probably feeling a lot of stress because the trial process is challenging and it's unknown. It's not something that we all experience, throughout our lives. So it's something that's really new and different. And of course, there's important issues involved. So presenting a powerful case at trial is really important. And the key here, one of the main keys, is understanding trial procedure. We're going to talk about that today in depth. I know the original title for the presentation was just about a divorce case, but I wanted to expand it to child custody as well, because there are a lot of child custody cases throughout the state, and a lot of these concepts are exactly the same. So whether you have just a divorce or a child custody case, or maybe you have a divorce with kids, and after your divorce is over, you may have just some child custody related issues that end up going through the court. So this information will apply to both types of cases. So this presentation is really created to help you understand the process and have success in the courtroom. All right, let's get started. So you have a final trial date in your divorce or child custody case. What do you do? Once that date is set, what's next? Well, it's time to prepare. And you're probably wondering, what does that mean? How do I prepare? Well, number one is you want to start calendaring the important deadlines. First is a disclosure deadline, and we're going to talk about each of these in more detail. But disclosure is all the evidence or witnesses that you intend to use at trial. You need to share that with the other side. And it's usually around 30 days before trial that you need to do that. You'll need to reference the rules. You can see if there's a specific disclosure deadline in your trial setting order. But you want to make sure that you comply with that, because if you don't disclose your evidence and the other side objects at trial, that evidence likely won't come in. There's also a really big and important pleading called the pretrial statement. That is generally due 20 days before trial. Your judge could set a different deadline, but per the rules, it's 20 days. So, look at your actual trial setting order to see if there's a specific date for the pretrial statement to be filed. If there isn't a date, then the 20 days before trial is the deadline per the rule. We're going to talk in detail about what goes in a pretrial statement and about why it's so important. Exhibits. What are the documents, the pictures, the recordings, the text messages? What is the evidence, the documents that you want to present at court, or maybe it's a video, but what are those exhibits you want to submit? And each court has very specific rules. And in fact, it can even vary per judge about how they want their exhibits submitted to the court prior to the trial date. So there's going to be a date they need to be submitted. In Yavapai County, it's 5 days before. And with 5 days, you're going to want to count court days the court is open, not weekends or holidays. So, there's all these little nuances, but you want to be really clear, what's the exhibit deadline? And then how do you submit your exhibits to the court ahead of time? Is it electronically? Do you print out the hard copies, file them? So we'll talk about those considerations in more detail. And then, of course, you want to calendar your trial date. So get all of those dates into your calendar, whether it's in your phone, whether you have a hard calendar, make sure you've got it written down everywhere. Read your trial setting order and then read it again, because, just be really clear on the terms. Put all of those dates and deadlines into your calendar and make sure you are ready to comply with each deadline. Regarding disclosure, have you disclosed all of the witnesses you want to call to the stand? Have you disclosed all of the documents, the text messages, videos, pictures that you want to use? And keep in mind, disclosure is not filed with the court. Disclosure goes to the opposing party if they have an attorney, to the opposing party's attorney if they don't, directly to the opposing party. That's who you need to give these copies to. Give them notice of what your case, what you're going to present in your case. Once you get a trial date, or if you know that that's coming, immediately start drafting your pretrial statement. It's a really long and complicated document. We're going to talk more about it. And so I jump on that. It's not something you're going to want to leave till the night before or anything like that. Exhibits, you want to learn each and every rule for submitting exhibits in the courtroom that you're in, and prepare to comply. And then for your trial, I'm going to talk to you, or I'm going to teach you about how to draft a trial outline. This is not something you'll necessarily learn everywhere else. This is something I do in my personal practice. The trial outline is just for you. You do not disclose it to the other side. You do not file it with the court. This is your script to follow during the trial, so that when the judge turns to you and says, Mr. So-and-so, Mrs. So-and-so, present your case, you're ready to go because you have a script to follow. Now, it doesn't mean that you stick to that script so tightly that you are not ready to move and flow with what happens with the trial, okay? It's a guideline that you're going to follow, but of course, you need to go with the flow of your trial. But it's so helpful to have something to look at and go off of when it's your turn to ask questions. So you have questions to ask and you're not just sitting there trying to figure it out on the spot. Let's start now with a deeper dive into this disclosure issue. And so with the Rule 49 disclosure statement, now what we're looking at is you should have already done a disclosure statement in your case. Prior to getting to trial, you should have already done some disclosure. If you haven't, you need to jump on that. But one thing that goes in your disclosure is a list of all the witnesses. Are you going to be your only witness? Or are you planning to call other people to the stand? If you are intending to call other people, you need to disclose them. You need to disclose their name, their contact information, their address, their phone number. You could provide an email address. That's not in the rule, but it's about providing contact information. And so really, what's the best way to get in touch with this person? And then you also need to disclose a statement fairly describing the substance of the witness's expected testimony. And you're supposed to disclose all witness information at least 60 days prior to trial. So keep that in mind. When you are deciding what evidence to use at trial, you likely want to have one or two other witnesses, on the really heavily contested issues. Because if you've got an issue where you're saying one thing and the other side saying another thing, and there's nothing else to tip the scales, it's kind of a tough call for the judge. And the judge is going to have to go off of credibility. Maybe it's tough, but if you could add in some additional corroborating evidence or something like that, another voice that supports what you're saying, sometimes, of course, depending on the evidence, that can tip the scales and help make your evidence stronger. So consider that. You don't want it to be boring. Just, yes, here's another witness explaining that I have kids and I spend time with them, unless there's some allegation that you spend no time with your kids. Just explaining that you spend time with them may not be, really that powerful. But, someone who's going to talk about what your relationship is like and how you interact with your kids and how your kids respond to you, and getting into those best interest standards, that definitely could be helpful depending on your case. In addition to witnesses, you've got documents, videos, audio recordings, pictures, text messages are very popular exhibits in family law trials. Do you intend to present any documents? Let's say there's an issue about the title or to your house. Are you going to present the deed to your house as one of your exhibits? Do you have any videos? Do you have audio recordings? Do you have pictures? You'll need to make sure anything that you want to use at the trial you've disclosed to the other side. And with documents, it's generally 30 days of discovering the document. The bottom line is you want to disclose as soon as possible to avoid any allegation that you haven't met a deadline. But even if you haven't met these deadlines strictly, I would still get the evidence out there. Leave it up to the judge or leave it up to the other side to make an objection. But disclose. And when you're disclosing, you're thinking about what is going to prove my case, what witnesses, what documents, what are the issues, and what is the evidence that's going to be helpful. And then just remember that disclosure statements are not filed with the court. The whole purpose of disclosure is to provide the parties, each other, with notice of what each other's cases are about and what their witnesses and exhibits are. So you don't file those with the court. Just a quick little summary on this disclosure point. Biggest point is, if you don't timely disclose a witness or a piece of evidence, you try to introduce it at trial and the other side objects, the judge could exclude your witness or evidence, meaning the court won't hear the testimony from the witness or consider the document, recording, text message, picture. So if it's something important, get it disclosed and keep proof, show that you complied with this disclosure rule. All right, now let's talk about pretrial statements. Pretrial statements are governed by Arizona Rules of Family Law Procedure Rule 76.1, subsection F. So again, you can go online, access the Rules of Family Law Procedure and find this rule 76.1F to get the exact details. I've got some of it in the slides here. Now, what is a pretrial statement? Now, it's a court pleading. It's due 20 days before your trial date, and it provides the judge with an overview of the case facts and disputed issues. All right, so always keep in mind the judges have hundreds of cases. You are asking the judge to focus on your case for that moment of the judge's time, and you need to start giving the judge information about what's going on, and that's what this pretrial statement does. It gives the judge a summary of the case to read before the trial so that when the judge goes into the trial, the judge is already knows what the issues are, knows what the disputed facts are, and is ready to hear the evidence and then be in a position to rule on it. So this document's important because it's your chance to start influencing the judge about what you want the judge to do. Pretrial statements can be a joint statement where both parties put their information into the sections and it's just one big document. The judge can see everybody's positions in one document, or it could be a separate statement where each side submits their own statement and then the judge can read the two documents and compare them. It's really going to depend on your judge whether or not they have a preference for a joint or a separate statement. So that could be a question for your judge. You can see if it's in the paperwork. You can talk to the other side about a potential stipulation. But generally, the most important thing is doing the pretrial statement and submitting it on time. And then as far as submitting on time, 20 days before trial is the general deadline, but each judge does have the authority to set a different deadline. So again, always refer to your trial setting order to see if there's any different deadlines. All right, now we're going to talk about what to include in the pretrial statement. We're going to go through a lot of different points. This is coming directly from Rule 76.1F. So what you'll want to do in your pleading is create the pleading and then make all of these separate sections your headers and then fill in the information below. So for example, paragraph 1 of your pretrial statement is where you would describe the nature of your action. So if you have a divorce with kids, something like, this is a dissolution of marriage with minor children. The issues in dispute are parenting time, child support, and what to do with our house. That would be a description of the nature of the action. But if you're struggling even getting that far, you could just explain, this is a child custody establishment case, or this is a divorce without children case, but just a brief description of the nature of the case. Second paragraph heading. Number 2, each party's name and address, if not confidential. Okay, pretty easy. You can handle that, right? Number 3, the name and date of birth of each minor child. If your case doesn't involve children, you would just put NA. But if your case involves children, then include the name and date of birth of each minor child. That, of course, is common to you and your spouse or co-parent in this case. So if you have other children that aren't in common with the opposing party, you don't need to list them. These would be listing the children in common. Okay, number 4, any stipulations or agreements that you've reached with the other side. That would go here. If you have none, you put none, but I highly encourage you to try to reach some stipulations and agreements. That's really helpful. Number 5, a statement of the uncontested facts or law. So are there any facts that you're in agreement with? For example, your date of marriage, whether or not you're in the military, that you've lived in Arizona for 90 days before filing. Like, there's a bunch of set facts that qualify you to get divorced, and those could be listed in your set of uncontested facts. Regarding the law, you could agree that the best interest of the child statute applies. So if there are any facts or law that you agree on with the other side, those would be listed in paragraph 5. And we've got paragraph 6. So in paragraph 5, you're going to talk about what's uncontested. In paragraph 6, that's where you start listing out what's contested. And you'll see there's these two sides of it, the facts and then the law. So contested facts, for example, could be, what if you are saying that it's best for your children to stay with you because they're involved in certain extracurricular activities and you're better able to get them there. But the other side is saying, no, I'm able to get them to the extracurricular activities. That would be a disputed fact. Who's able to get them to the extracurricular activities? Who is it? So that could be one example. It's not the best example, but that's one example. So are there facts regarding if you're doing a divorce, property division, spousal maintenance, legal decision-making, parenting time, child support? Are there any facts related to those issues that are contested? And then what about the law? Are there any points of law where one side is saying, this is the law, and you're saying, no, this is the law, or how to interpret it? Those things would be listed out. Paragraph 7, your position on each contested issue. So you've listed out what's contested, and now you're telling the judge how you want the judge to see the contested issues. Number 8, if either side is requesting spousal maintenance, the amount and the duration that's being sought. If parenting time is at issue, what's the schedule you're requesting, including holidays, vacations? A year-long parenting plan needs to be fleshed out for the judge. What is your exact request? What's your list of witnesses? If there were any depositions taken in your case, then you would designate what parts of the deposition testimony you want the court to consider. If your case does not involve any deposition testimony, then you just say does not apply. If you object to the other side's witnesses, in paragraph 12, you would list what your objections are and why. You could say they didn't disclose this person, or this person has no knowledge about what they claim they're going to testify about. In paragraph 13, this is where you're going to have your list of exhibits. And also, this is where you're going to list what exhibits you object to that are the opposing party's exhibits. So you're going to list out yours and any objections you have to the other sides. Also, it's a really good idea to reach out to the other side and share your exhibit lists and see if you agree that any exhibits can be admitted. So what's in agreement to be admitted? What's what are the objections, and what's each party's list of exhibits? That's going to be in 13. Paragraph 14, this is just a statement about whether or not discovery and disclosure has been completed. So if you're like, look, the other side hasn't given me anything, you can make a statement explaining that. Or, if the other side's claiming you haven't complied with discovery and disclosure, this is where you can explain that you have, if that's the case. Paragraph 15, whether or not you in good faith have tried to discuss settlement with the other side, and if not, why not? So the courts really want you to at least try to discuss settlement. 16, any requests for attorney's fees. And finally, 17, a statement about how a verbatim record of the trial will be made. You're probably confused, like, well, I don't know. Well, there's a court reporter, or there could be, each courtroom is outfitted with a recording system. It's called FTR Gold, but you could just explain, the record, the verbatim record will be made using the court's recording system or using the court reporter. Okay. Pretrial statements are big. I know there's a lot to include in there. So this is why I say start working on it right away. And as you're working on it, you can reach out to the opposing side or their attorney if they're represented and try to reach as many stipulations as possible. What facts are not in dispute? What law do you both agree applies? What exhibits do you both agree should be admitted into evidence? And then also, let's say you've got a couple witnesses, but one of them has a scheduling conflict and needs to testify first thing in the morning, but you don't go first. You could reach out to the other side and ask, look, this is what's going on with my witness. I'd like for them to testify first thing. Can we stipulate to that? And I've done that a lot of times. And so just keep that in mind. If you have multiple witnesses, you're going to need to, start figuring out at what point are they going to testify and if they're available at that time and if you need to get any concessions. You also need to attach some documents to your pretrial statement. This is per Rule 76.1. If your case involves child support, spousal maintenance, or attorney's fees, you need to attach an AFI. You should have already filed one in your case by this point. And keep in mind, the AFI can constantly be updated. Like if new numbers are in, you should update your AFI. But your most updated AFI needs to be attached to your pretrial statement. And if it's a newer AFI, that you need to file it with the court as well and attach it to your statement. If child support is at issue, you need to include your child support worksheet, which is going to show all the numbers you want the court to use and the final amount of child support that you're asking the court to order. And then if your case is a divorce, legal separation or annulment, then you also need to include what's called an inventory of property and debts. It's a set form that you can find online, and it lists out all of the marital property and debts that were acquired during the marriage that you still have now, a list of separate property and debts, and then any equitable lien claims. That's, I know, a little bit confusing, but if your spouse owns property that's not marital property, but the marital community has put money into that, or there could be what's called an equitable lien claim, I definitely consult with an attorney about that. And then the titles by which the property is held, the amount of any encumbrances, and your position regarding the value of the property, and then your proposed distribution. So this inventory of property and debts for divorce, legal separation, or annulment cases is really listing out all your property, the current values, and how you want it to get divided. Okay, so just as a final summary to wrap up the pretrial statement section, the pretrial statement is due 20 days before trial, and I would immediately begin working on it because, as you can see, it's really detailed. There's a lot involved, and it would be really tough to draft a comprehensive quality pretrial statement like the night before it's due or something like that. Okay, trial exhibits. Let's talk about how to submit exhibits to the court. What are trial exhibits? Well, documents, text messages, videos, audio recordings, photographs. Now I've got this image over here of a text message, and I wanted to highlight this because when you're going to use a text message as an exhibit, there's a couple of things that you want to be aware of. Number one, you should have the date of the text message in there somewhere. So maybe you have to go back and take a screenshot a bit higher up to get the date, and then the other screenshot so you can show the flow. But it's a potential objection if you submit a text message as an exhibit and it's not clear what day it was, and you don't remember, you just go, oh gosh, I don't know what day this was. I've just got the document. I just remember the conversation. It could get excluded. So you either need to know and have it labeled, or you need to do a proper screenshot where it's going to include the date. And so that can be helpful. And then also for text messages, they're going to need to be printed out if you need to submit hard copies of exhibits, or they're going to need to be converted into PDFs to submit as e-files for e-exhibits. So, again, this is something where you're not going to want to wait till the last minute, because there's just some logistical issues here of getting everything ready to submit, and making sure it has all the information and it's lined up properly. So that's what trial exhibits are. And then let's talk about filing your exhibits with the court. So in your trial setting order, there's most likely going to be an exhibit deadline in there somewhere. Exhibits, at least in Yavapai County, are submitted 5 days before the trial. So see what it is in your county. And the big question for you is, how does the court want my exhibits? Are they taking hard copies? Are they taking e-copies? That's something you can call the clerk's office or go visit and get that information. So once you determine how exactly to submit the hard copies or the e-copies, if you're doing hard copies, you're not going to want to have all of your documents just loose. If an exhibit is 5 pages long, staple the 5 pages together. If it's 2 pages long, staple the 2, because you're going to otherwise just have papers everywhere, and it's hard to work with. Also, let's say you've got a 50-page exhibit. It's like medical records or counseling records or something. You're going to want to number the pages on the bottom. Even if you use a pencil or a pen and just write it in on the bottom corner of every page, because when you present that document to a witness, you can say, hey, turn to page 25. Otherwise, you got a 50-page document, and how are you going to get the witness to the page you want to go to unless you've got your pages numbered? And then also, if you're submitting, or when you're submitting your exhibits to the court, it's really nice to have a cover page. It can have your case caption, your case number, and then it lists out all of your exhibits with numbers. Then you have a master exhibit list. Keep in mind, if you start with number 1, and let's say you have 10 exhibits and you submit your 10 exhibits, when you get to the trial, your exhibits may not be numbers 1 through 10. If there's been prior exhibits entered or the other side submitted theirs first, the exhibit numbers keep going in chronological order. So understand that when you get to the hearing, the court will give you a list of the final exhibit numbers. And so look at that and incorporate that into your trial outline, because your 1 through 10 may turn into 50 through 60. So just, be ready to go through the flow with that and update your documents and be ready, because the numbers could change. You also are going to be required to provide the opposing party or their counsel with a copy of your exhibits. So you can reach out to them, ask them, would you like hard copies or e-copies? If the e-copies, you can just email them over. If they want hard copies, you need to print them out, and you either need to mail them or hand deliver them to the opposing party. Now, I also suggest that you make for yourself a trial notebook. So a trial notebook is a 3-ring binder, and I suggest that you print all of your exhibits out and get tabs and everything, and have a nice organized trial notebook with all of your exhibits. And I would include the opposing party's exhibits in there too. Because when you're in the trial and an exhibit is introduced, the witness is going to be holding it. So if you want a separate copy to look at, you need to bring that with you to the court. So that could be in your trial notebook, have all the exhibits in there. I always print out a copy of my pretrial statement, my trial outline. I've got everything there in my trial notebook. So just to wrap up this trial exhibits section, remember, if you don't follow the court rules for trial exhibits, the judge may never see critical evidence you want the judge to consider. So we are going to talk in the next section about how to actually introduce an exhibit and get it admitted into evidence at the trial. But this section just talked about filing your exhibits with the court, and preparing them to file them prior to the trial by the deadline. But we will talk about how to actually get an exhibit admitted into evidence. All right, final section, your trial outline. Now, this is something special I'm sharing with you. This is not part of the court rules. This is not anything required by the judge. This is something I do as an attorney. I make a trial outline anytime I have a hearing or a contested trial. And it's for me only. It doesn't get filed with the court. A copy doesn't go to the other side. This is just for me to use during the trial. It's my roadmap It tells me exactly what I'm going to do, what witness I'm going to call next, what question I'm going to ask, what argument I'm going to make, what exhibit I'm going to present. It's my script. Now, am I stuck to that script in a really rigid way? No, I got to go with the flow. If an objection comes up I wasn't expecting, I'm going to need to address that. If the judge asks me a question that's not in my script, I'm going to need to address that. If the witness says something, I wasn't expecting, I need to go with the flow. But I have a guide to help me along the way, which is so nice and really cuts down on the nervousness and anxiety because I'm walking into the court with a plan and a script versus going in there and being like, I don't know what's going to happen. I don't know what I'm going to say. Oh my God, you have a guide. So what is in your trial outline? Your opening statement, your direct examination questions, bullet points for you to refer to when you testify. We'll talk about this some more. Your cross-examination questions for opposing parties' witnesses and your closing argument. When you are creating your trial outline, I suggest you start with your closing argument. I know that that technically is the end of the case of the trial presentation, but that is where your whole case comes together. And it's so helpful to start here because then you have something to guide you through what you're presenting. Okay, so in your closing argument, I would start typing it out. What is the story that you're telling the judge? And when you tell this story, you need to be crystal clear that the judge knows nothing about you. You need to tell your story as if you're talking to somebody who you've met for the first time. So instead of these general words like he, she, it, them, they, their, you need to be specific. Johnny went to the ice cream shop on Thursday at 2:00. Not he went there then. With everything you present, you want to be crystal clear with the term or with the story. Also, you want to make sure that you give enough detail so that the judge has enough of the backstory to lead up to where you are now. So we got married in 2007. We have 2 kids. These are their names and ages. This is where they go to school. This is what their schedules are. This, like there needs to be, you can't just say, oh, my daughter, my daughter, Julie, who's 8 years old, who's in school, has no special needs, whatever your situation is, you really need to go in there being like, I'm talking to somebody who I've never met before in my life. And I'm going to need to give them sufficient amount of detail. So you're starting to draft your closing argument and you're telling your story. And in that story, you're arguing for why the judge should rule in your favor. So if you have a divorce, start with property division. In your closing argument, what are you asking the court to do for property division and why? Why is your request fair? Why is the other side's not fair? Where's the dispute and why is your argument better? If spousal maintenance is an issue in your case, that could be the next part of your closing argument. Regarding spousal maintenance, it should be denied and this is why. Or regarding spousal maintenance, it should be X amount per month for this many years and this is why. Parenting time, child support, legal decision making, whatever the disputed topics are in your case, you should be writing some paragraphs about those, arguing your argument to the judge. And of course, write it, go back, pare it down. Like this isn't something you necessarily just write once and it's over. Like this is something that could take you a few weeks to write. And then you, oh, wait, what about this? Oh, and I want that in there. Oh, wait, oh, that's way too wordy. Okay, so this is what a trial outline looks like. First part is your opening statement. Now, keep in mind, it's a statement. You don't make arguments in your opening statement. It's very brief, a couple of sentences, and it's often waived because the courts have such limited time that often just be like, oh, I waived the opening statement. Judge, you read my pretrial statement. Let's get into the evidence. Let's get into the witnesses. But if you're going to give an opening statement, it'd be good to have something written out in your trial outline. So again, if the judge turns to you, oh, Mr. So-and-so, Mrs. So-and-so, give your trial outline or give your opening statement, you have something to say. So judge, this is a divorce case. We have 2 kids. The disputed issues are property division, in particular, the house, our parenting time and child support. Thank you, Judge. That's simple. You can also give the judge a little summary of what witnesses you're going to present. Hey, Judge, I have 3 witnesses today. Da, 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 da. Thank you. What's next in your pretrial outline? Well, are you the petitioner or are you the respondent? If you're the petitioner, and this could get kind of confusing because in post-decree matters, after you've had your initial divorce or child custody order, you could go back to court and it could be the respondent that initiates the case. So it's not always the petitioner that's the one that's initiated the case, but it is in a divorce and it is in a child custody establishment. So we're going to look at it from that perspective. So the petitioner is going to go first, and the petitioner is going to call their witness to the stand. And so if you're the petitioner, you're going to want to draft direct examination questions for each witness. We're going to talk a little more about that. If you are the respondent, you're going to want to draft cross-examination questions for each of the petitioner's witnesses. If you're the petitioner, you need to draft direct examination for your witnesses and cross-examination for the other side's witnesses. If you're the respondent, you need to draft cross-examination questions for the petitioner's witnesses and direct examination questions for your witnesses. For the petitioner, you can have some rebuttal witnesses. So the flow of the trial is opening statements, then the petitioner goes. Petitioner calls a witness to the stand. They do direct examination. Then the respondent gets to ask that same witness cross-examination. And then the petitioner gets to do a final examination called a redirect. And then that witness is done. The petitioner can call another witness. Same procedure. Direct examination, cross-examination, redirect, witness is done. If the petitioner is representing themselves, they can say, Judge, I want to testify, and they can go up and take the stand and testify. And if that is what you're doing, it can be really helpful to have bullet points about what you want to tell the judge. So you're not just going up there and just talking off the top of your head when you're really nervous. If it draws an objection, hey, what's that piece of paper? Judge, these are some bullet points about what I want to testify about. I came prepared today. Once you're done testifying, you'll be subject to cross-examination. Once the cross-examination is over, redirect. You get to say some final things. And what that means is whatever came up on cross-examination, if you want to talk some more about stuff that came up on cross, that's what redirect is for. Once the petitioner has called all of their witnesses, then it's the respondent's turn. Okay, respondent, call your witness. Okay, I'm representing myself. I'm going to testify. You get up there, testify, then you're subject to cross-examination by the petitioner, and you get a final chance to do some redirect. Then you can call your next witness if you have one. And then you would ask them questions on direct. They'd get cross-examined. You could do redirect. You do that for as many witnesses as you have. Once all of the witnesses are done, closing arguments. Closing argument is an argument. Now, whatever you draft for your closing argument, you may not have sufficient time to present it because the trial time that the courts have is so limited. And so you may only get a chance to say a sentence or two by the time you're in the actual trial, but still draft it anyways. Whether or not you actually get to present it doesn't matter because it's going to help you get your mind around what your case is about. Remember, when you go into the courtroom, you're telling the judge a story. How are you telling your story? There's 100 different ways to tell a story. How are you telling that story? That's what your closing argument's about. And that is going to take you through your whole presentation. Why start with your closing argument? This is going to help you illuminate the facts and arguments you want to make during your trial presentation, really help you get clear on what is most important. What 5 things do you want the judge to know when your trial's over? What are the, just as an example, what are the 5 things the judge has to know about your case? That, highlight that in your closing argument. Get really clear on your case themes and theories. Use your closing argument to draft your direct and cross-examination questions. This helps you bring everything together. Otherwise, you may feel like you're drowning in facts and arguments without any clarity. And as we've talked about, the judge has so many cases. You've really got to make a powerful presentation. Regarding questions, direct examination is non-leading questions. For example, what's your name? Whereas cross-examination is leading questions. Your name's Julie LaBenz, right? So on cross, you're really making a statement, comma, right? And you're looking to get the person to answer yes or no. Whereas on direct, it's more broad. What is your name? What happened next? Then what? What did you, versus cross, your name's Julie, right? So you got to work on that. It's quite an art. Also consider using signposting. This is where you're going to introduce the next line of questioning. So you're questioning your witness or you're testifying. Hey, judge, now I'm going to talk about legal decision making. Hey, judge, now I'm going to talk about parenting time and get into those questions. So signposting is really nice to let the judge know what topic you're going to be addressing in those set of questions or in your testimony. Exhibit admitted into evidence. So let's say it is exhibit 1. Judge, please hand exhibit, or the bailiff, or it'll be you. I'd like to present exhibit 1 to the witness. Witness, what is exhibit 1? Well, this is a copy of the title to the house. Okay. Is this a fair and accurate copy of the title to the house? Yes. Move to admit. So the witness needs to identify what the document is, explain that they know it's accurate, and then move to admit it. Work on your trial outline, and then just some final points. All you can do is your best. Every trial will have at least one curveball you don't expect. Establish reasonable expectations for your trial. Understand the final outcome isn't up to you. If you're going to reach an agreement, yes, but if you're leaving it up to the judge, it's up to the judge. No case is perfect. Every case has weaknesses. All you can do is the best you can do. Be consistent. Prepare, prepare, prepare. Make settlement offers. Try to resolve as many issues as you can outside of court, and try not to beat yourself up too much after the trial. Representing yourself at trial is really tough. Thank you so much.